I'm going to now introduce Caitlin Thompson, who is the NC Realtors Chief Legal Officer, along with Austin Smallwood, who is her counterpart, Vice President of Legal Affairs and Public Policy for the South Carolina Association of Realtors, who will offer state association updates. And I just want to thank you to everyone of the presenters who joined us virtually, and also to the audience who's attending virtually. And I am going to let you know that Caitlin and Austin should be on.
I've been asked to cover several different things that are happening in North Carolina. And one of the first things that I'm going to go over today is some rule changes related to commission required education. So this essentially is affected by two different rules, which could impact you all in a variety of different ways. So first, there was a repeal of a commission rule. This eliminated any distinction between resident and non-resident brokers and their CE requirements. And then there was an amendment to a commission rule, which no longer allowed brokers to request equivalent credit for completing an unapproved course, such as another state's real estate CE course. So what does this mean for you? Essentially the bottom line here is that anyone with a North Carolina real estate broker's license, regardless of where you live and work, will now be required to complete the appropriate update course, either the Gen Up or the Bic Up, and an approved North Carolina real estate elective each license year by June the 10th. So the North Carolina Real Estate Commission tells me they are working on trying to get this message out so that brokers are not caught off guard. They tell me that a message was already displayed on your renewal screen, and they ask that I please remind you to keep your email up to date with them. So you'll receive their emailed reminders about these changes. You subscribe to their month bulletin online, which has information about those changes posted to it. All right. So next, I want to talk about a couple of hot topics, hot risk management issues that are frequently coming into our legal hotline. So the first one of the two that our hotline lawyers tell me that we're getting a lot of calls about still is misrepresentation and due diligence fee refunds. As you might imagine, during some of the height of COVID and lots of multiple offer situations, we got a lot of calls about this, but we're still receiving a lot of calls even now. So I want to go over a few things related to this. First, a buyer's due diligence fee is generally non-refundable, but of course there are some exceptions to this. So for example, our offer to purchase and contract form 2T states that if a seller materially breaches the contract and the buyer elects to terminate the contract as a result of that breach, the buyer is entitled to a refund of the due diligence fee, among other remedies. North Carolina recognizes two types of misrepresentation claims. One is fraudulent misrepresentation. That's going to be your intentional misrepresentation, and one for negligent misrepresentation. That's going to be where most of the litigation lives. So to establish a negligent misrepresentation claim, a claimant must show that they multiple factors. One, they justifiably relied to their detriment on information prepared without reasonable care by one who owed the relying party a duty of care. So misrepresentation claims can be based on the conduct of the seller's agent under North Carolina law. There is case law holding the seller of real estate bound by their agent's material misrepresentation to the same extent if they would have made them themselves. So in these cases, the seller can be held liable for the misrepresentations of their listing agent. And it would likely come down to a judge to decide if the agent acted with reasonable care. So we have a recent legal Q&A on this that goes into more detail and gives some more examples, but that's something to consider checking out since this is still a hot issue that we're seeing in North Carolina. The next one I wanted to talk about is breach of contract as defined in the offer to purchase and contract in North Carolina, our Form 2T. So breach of contract generally means the failure without legal excuse to perform any promise contained in the contract. So some common breaches of contract by the seller are things like failure to deliver good title to the property at settlement as required under the contract, failure to provide the buyer reasonable access to the property through closing, failure to make any agreed upon repairs in a good and workmanlike manner, removal of an item on the list in the contract that's not been excluded from the sale, such as a storage shed or a hot tub, and failure to perform the seller's obligations by the settlement date. Common breaches of contract by the buyer are going to be failure to timely deliver the due diligence fee and any initial or additional earnest money deposits. Failure to complete the transaction by the settlement date due to the inability to obtain financing or close on an existing party. So there are rights if a party breaches the contract. Generally, if one party to a contract commits a material breach of the contract, it discharges the other party from any further duty to perform its obligations under the contract. The contract's not void, it is voidable at the option of the non-breaching party. Whether or not a breach is material will depend on the circumstances. You hear us say that a lot of lawyers, it depends. But in general, a breach of contract is material if it has influence or effect on the transaction that's not insubstantial. To give you an example here, a seller's would not likely be a material breach of contract for failing to comply with the obligation to remove all of their personal property, garbage, and debris if during a final walkthrough the buyer discovers they left a single bag of trash in the garage. So the seller has rights if there are rights for both parties if there's a breach of contract. If there's a breach by the seller, the buyer could elect to terminate the contract and recover damages as well as any earnest money deposit. In 2T, the buyer's damages would include, but aren't necessarily limited to, the recovery of any due diligence fee and costs incurred by the buyer. The buyer may also seek to enforce the contract rather than terminate it. This is what we call specific performance. But a buyer, in this case, a broker needs to make sure they are advising their buyer, in this case, to seek legal counsel to help them to determine whether or not that's a remedy that they should consider pursuing. So the seller also has rights if the buyer breaches a contract. Under the contract, the payment of any earnest money deposit to the seller and the seller's retention of the due diligence fee will serve as their liquidated damages. And that's the seller's sole and exclusive remedy for the buyer's breach of contract. When you are discussing any amounts of due diligence fee and earnest money deposits, the seller may be willing to accept to put the property under contract. You need to make sure that you are making it clear to the seller that these are amounts that they would be entitled to receive if the buyer breaches the contract. We have a new broker and consumer guide on this topic that, again, goes into more detail, gives you some more examples, which brings me to a resource that I want to mention to you. So NC Realtors recently launched an updated version of our website, and with that, we have launched a risk management tools library. There are broker guides, consumer guides, as well as slide decks as part of this library. These were developed by our NC Realtors attorneys with input from NC Realtors Risk Management Committee. So I encourage you to check them out. You'll see tools there that cover the topics that I covered, as well as many others. So this is the main page of our website, and you can find them there right on that tab that I've put an arrow to here. As always, just a reminder, as an NC Realtors member, you have access to NC Realtors Legal Hotline. We have 3 attorneys that staff that hotline: John Waite, Bill Gifford, and Adam Stallings. If you have additional questions related to anything that I went over today for one of your transactions, be sure to reach out to them so they can give you some guidance and help you with that. There's their number as well as the email. And then finally, I want to mention we have forms changes that are launching July 1. A detailed summary of those changes are already available. They're up on our website, so you can take a look through those. And I'm not going to go into detail on the resources for you if you want to have an opportunity to answer questions. Get your questions answered. So Canopy is hosting an education event on July 14th, and NC Realtors is hosting a education event on July 17th. You can find both of those on the respective websites. So please be sure to check those out. So with that, I thank you all for letting me participate today, and I will turn it back over to Anne-Marie.
So I think we're going to go right into Austin Smallwood presenting. So if everybody could welcome Austin, he will be here in a minute.
Okay. Good morning, everyone. Appreciate you all having me here this morning. For those of you who I haven't had a chance to meet, I'm Austin Smallwood. I'm one of the attorneys with SCR. So if you are an SCR member, like Caitlin mentioned, for North Carolina members, we also have a legal hotline that is available for any license law, forms, questions, anything like that you may have. And that number is 803-772-5206. If you are not an SCR member but do practice in South Carolina, I wanted to let you know that you do have the option of getting a secondary membership with SCR, which would just mean you would get a membership directly with SCR. You wouldn't have to pay additional local or national dues. It would just be the state portion that would give you access to all of our forms, legal hotline, advocacy, all those other benefits. If that's something you're interested in, surely reach out to me. I can get you in touch with our member services department, or you can reach out to them directly or give our main line a call. So I wanted to hit 4 main topics today, and then I know we're going to do some Q&A. So the first thing I want to mention is if you are in South Carolina renewing this year, that renewal deadline is midnight, June 30th. So that is coming up. You need to make sure that you are renewing by that deadline. If you don't, your license on July 1st will go into being a lapsed license. So what does that mean? Well, as a licensee, as a salesperson, it means that you cannot practice real estate until your license is reactivated. Not that you resubmit, not that you submit your application, but your license will actually have to be formally reinstated by the commission. You're also not going to be able to price real estate. Doing so would be a violation of license law. So you can't go talk to clients. You can't be in open houses. You can't go into the office. You essentially are on the sidelines at that point. You can't receive commissions, regardless of when that contract went under. A broker cannot pay you because at that point you are not somebody with an active real estate license. So you cannot be paid on any commissions if your license is in lapse status. If you're a broker in charge and your license goes into lapse status, that actually will essentially shut down the entire brokerage. So none of your licensees under you will be able to participate in real estate. You won't be able to compensate them because that would be also unlawful. So a lot of really bad things happen at that point. As a broker in charge, you are not going to be notified by the commission which one of your licensees is not renewed. Under your broker supervision requirements, it is your job to know that information. So I would go back to your office after this and go and look at which one of your licensees are renewing in 2023, and then do an email follow-up with each one of them to make sure that they've actually done so and ask for proof that they've done it. And then July 1st, July 2nd, you need to go and check to make sure that that's done, because the commission is not going to email you. They're not going to notify you and say, hey, these 5 agents of yours have not renewed. The numbers that we've heard from the commission are not where we would like them to be on the renewal front. I think there are a lot of folks who think that they've got an additional 6 months. The 6 months between June 30th and December 31st is before your license is canceled. That is not an extension for getting your license to remain active. So July 1, if you haven't renewed when you're supposed to, your license is going to go into lapse status. If you haven't renewed at all by July 31st or December 31st, your license is canceled, meaning you've got to start all over. You got to go back to real estate school, take the test. There is no fingerprinting that's required this year. So all you need to do to reapply is simply fill out the application and submit all of your CE. If you have any questions on any of that stuff, certainly reach out to me or the commission. The next thing I'm going to bring up is, and I'm going to share my screen, is one of the new forms that came out from the commission on June 1st, and that is the property disclosure, seller disclosure, residential property disclosure statement. So I've kind of gone through here and highlighted where the big changes are. So any form that you have, any transaction that you've taken post June 1st needs to be using this form. We've updated this with all of our forms vendors, so it was sort of a find or replace, so you don't have to worry about any of that sort of stuff. But just make sure that anything new you need to do on this form, if it was something that you went under, took a listing on May 30th, you could still use the old form. All that stuff is grandfathered in. If it's been 4 or 5 months, maybe you try to update it, but there's no requirement to do so. So the first substantial change, and this is the one that you really need to stress with your sellers, is what no representation means. So no representation has been misunderstood in the past as I just prefer not to answer the question because the question isn't going to look good for me. That's not what it means. No representation means I legitimately do not have the actual knowledge necessary to tell you yes or no. I don't want to say yes and unnecessarily stigmatize my property. I also don't want to say no and be potentially inaccurate. No representation is I legitimately have no idea whatsoever. Now, if you subsequently get an idea, you have to update your seller disclosure. Your seller disclosure, the seller disclosure as a seller is a living, breathing document up until closing. At any point, anything on that seller disclosure becomes inaccurate, the seller has an obligation to update that. They don't need to do a brand new disclosure. They can simply amend the existing one that they have. By the way, putting no representation does not waive the seller of any of their liability should that have been an inaccurate answer. So page 1 of this form, please explain that to your client. That is all, make sure they're clear on it. Once we start getting to you cannot explain this to your client. You cannot fill this out for your client. They need to do that solely with the advice of their attorney. So I'm going to kind of quickly go through some of the questions that changed. But again, any questions your client has on what that means or whether or not that applies to their particular property, they're going to need to go through legal counsel. So questions 5 and 7 were sort of split. Previously, there was one question asking about roof, foundation, and the structure. It was getting confusing because sometimes those dates don't align. So there's now a separate date time for asking when the roof was installed or any leaks, and vice versa with the structure, foundation, slab issues, etc. On Roman numeral 4, there was some questions we were getting on the hotline about whether or not this applied to squirrels, bats, raccoons, possums, because they weren't technically wood-destroying organisms. I think that's something buyers would want to know about. So that has been added to make sure that Roman numeral 4 is including all possible pest infestations. 18, there was an added question to make sure that there's a first right of refusal on the property that's being disclosed. And then 22 through 28 is really the heart of what was added here. A lot more questions about flooding issues, for whether there's been flood insurance, if there's been any claims due to flood damage, has that been done through private insurance, public insurance? Was it not even filed? Damages, things of that sort. So just make sure that your client is making all those appropriate disclosures. And then some additional sort of reinforcing that the Vacation Rental Act, which we have in South Carolina, is for 90 days after the interest is recorded at the Registered Deeds Office. So any short-term rentals that are on a property, vacation rentals, Airbnbs, VRBOs, those have to be honored within 90 days of closing or when those instruments are recorded with the Registered Deeds Office. But so we have a video on YouTube that goes over these changes. It's about 3 minutes or so. So I recommend that you check that out if you have any additional questions. anytime or update, we tend to do a very short 3 to 5, 6 minute video on the forms change on our YouTube channel. So you can always find those, just, search as an also YouTube channel, and that will sort of let you get a sneak peek or first alert of whenever those videos go out. The next form I want to briefly touch on is one of our ones that we recently updated, and that is Form 130. That is our buyer agency. That went in, this new version of it went into effect on March 20th. The biggest change here was in regards to brokerage fee. We previously had two options in there, one of which was the, if I don't get paid from the transaction, I don't get paid at all. That was removed. That was being misunderstood and misdescribed as the free option. Obviously, under standard practice 12.1 in the Code of Ethics, you cannot disclose any or advertise something as free if you possibly are going to get paid for it. So what we have here is now a buyer's going to pay a broker a fee of whatever amount it is. That's going to set the floor for you as an agent or as a brokerage. And then, of course, any amount that the listing side is going to pay is going to be credited against that, and you're going to make your best efforts to obtain that payment. Best advice I can give for you here is your client is going to sometimes get very upset after they read the first sentence. Make sure they read the next two sentences. That will make them feel a lot better, that they understand that the credit, anything that's offered in the MLS or the other side is paying, or if it's a FSBO, anything that's going to be paid from the transaction is credited against that amount. But anything that is left over would be the responsibility of the buyer. The better job you do of explaining your duties in paragraph 3 and selling your services and selling why did this buyer decide to work with you, the easier that conversation gets in paragraph 5. If you simply blow through paragraph 3 and just go, here's where my duties are to you, and you move on, then it's going to be a lot harder to have that discussion when you start talking about the compensation. So the easier you can make this conversation for you, that I would try to. So really sell your services. Explain, there's a reason you work with me. Here's why all the benefits you get of working with me. This is a professional service, no different than hiring an attorney, CPA, listing broker, anything of that sort. And then the last thing I want to make sure I cover, because this is something I know we get a number of questions from in y'all's area, is due diligence. And I know Caitlin touched briefly on the North Carolina due diligence. I wanted to clearly point out there's one big difference with South Carolina versus North Carolina on due diligence, and want to make sure everybody's clear about it. So due diligence in North Carolina is a due diligence fee that's paid up front. Ours is not a due diligence fee. It is a termination fee. So that termination fee is only paid if the buyer terminates during due diligence. That is not an upfront fee. That is never paid up front. It is, a successful transaction will never see a termination fee. That is simply what is the buyer willing to pay to be able to get out of the transaction during the due diligence period. Also, unlike North Carolina, we have a couple of contingencies that are outside of due diligence. They all stand on their own. If the buyer is terminating under one of these, they will not owe the termination fee. Those would be financing, which is paragraph 7, appraisal, which is paragraph 10, CO100 or wind infestation, which is paragraph 11, or if they have a buyer sale contingency, which is a separate form, form 504. So if you're ever curious if there's going to be a termination fee owed, there's really two questions to ask. One is, are we in the due diligence period? If we're outside of the due diligence period, the answer is always going to be no, because the termination fee is only for a termination during the due diligence period. The second question is, why are we terminating? And if the buyer's terminating because of one of these other contractual contingencies, the answer is going to be no. So if the buyer's terminating because their financing fell through, even if their financing fell through during the due diligence period, they will not owe the termination fee. So asking your buyer, why are you terminating? Because of which paragraph? And if they can name a different paragraph, then the fee's not owed. But if they go, I'm terminating because of due diligence, regardless of why they are, they're going to have to pay that fee. Sometimes the buyer's going to be happy to pay it because the buyer's moving on to a different property, or they found something at the home inspection they don't like. And sometimes they're not going to be happy to pay it. But that is something the buyer needs to be aware of when they put that amount down on that termination fee blank. Ultimately, I don't recommend that brokers or agents advise what that number should be, because they're not the ones who are going to have to write the check. So the buyer will have in their head what a number they think is appropriate for this, and let them put that number on there. And if the seller doesn't think that's appropriate, the seller can certainly counter back. But what you don't want is a situation where you tell a buyer what number would be good. That's more than they are willing to pay. And now they sort of hold you responsible for having cost them that amount of money. But that's probably the biggest difference between the North Carolina and South Carolina contract, especially on due diligence. So also, if you're working with a client that's looking on both sides of the border, and they say, well, I understand due diligence, make sure they understand that the two due diligences are not the same, that they need to actually read the exact verbiage of their contract and be aware that if they put some large number now, that's not going to be a credit at closing. It's not something that you pay up front. It is simply a termination fee, but is a fee that is required to be paid in order to validly terminate under due diligence. And then the last thing I will put up here is I want to go ahead and put all my contact information should y'all have any questions. Certainly, we're always happy to answer whatever we can to make y'all's life a little easier. So that top number is our legal hotline that will reach any of our three attorneys, myself, our general counsel, Byron King, or our director of fair housing, Tiara Pitts. And then the last two parts are my email. That's a good way to reach me. Is just email me directly, austin@fcrealtors.org. Or in that last number is my direct line. Again, appreciate y'all having me here this morning, and happy to answer any additional questions y'all may have.
Thank you. I'm going to say thank you to Caitlin and Austin. And I think everybody in the audience has your contact information if they have follow-up questions directly to you, or they can go through us. So I want to thank you both.